Welcome to Thought Leaders, featuring interviews with some of the best minds in the industry. Today's special guest is popular platform speaker and trial lawyer, Ilya Lerma. Hello everyone, I'm Steve Savant, syndicated financial columnist and talk show host. In this segment, we're talking about why companies and contracts are not high-value targets in litigation. It sounds like I am. All from Ilya's best practices taken from her popular keynote addresses and seminars. When I first heard you talk about this, and especially when I saw you live, I didn't look at you while you were talking about this. I was looking at the audience. And so all the advisors are going, but I thought you'd go after the deep pockets. It's the carrier, the insurance carrier, the mutual fund manufacturer. He didn't disclose this. Why are you coming after me? Why wouldn't you go to the contract between the carrier and the client, or the mutual fund and the client?
Well, as I stated earlier, it all comes down to the relationship and really how the client interprets that relationship. And the real betrayal is when you have a 20-year, 15-year history with a particular client, and then they feel betrayed at the end. The product that they thought was going to produce doesn't yield the results that they think you promised, and they feel that betrayal. And that's a human kind of connection. That's built on a history of the relationship. It can sometimes be related to the company. And companies make promises. You know, we have different commercials that promise all kinds of things, and so we can conjure up memories or ideas of the commercials are advertising in terms of, you know, being safe and secure, and those ideas that relationships are built upon. But really, the person is the face of the company, and they're the face of the defendant when there's a case that goes into litigation. And that relationship is really the fundamental building block of any case against a producer, a broker, an agent, because you're going to be looking at, why does this story have an appeal to a jury? You know, how is it that my client felt betrayed? It's just words on paper, contracts, those feel cut and dry. And that may be the way the agent is looking at this information. They're looking at it as transactional, they're looking at policies, they're looking at intake interviews and life events that have been documented. But again, the person on the other side, your customer and my client, is looking at this as, this man promised me. You know, I was promised by this person that this is that I was going to be safe, that I wasn't going to be facing all these losses, that this product was going to yield these results for me, that my family was going to be looked out for. So to them, it's an entire story. And you have characters like any story, and you may have the background character of who the company is, but you also have the frontline person, and that's the agent, the individual agent, who's going to be the primary target as the agent representative for the company.
Well, Ilya, I don't like your answer. I'm just saying,
Nobody does.
Nobody does. I mean, I'm thinking, like, the carrier's got the deep money. They wrote the contract. They actually produced the product that we sold, and yet it seems like in our area that we're always the ones that have the huge target on our backs.
Well, it's not, and this is going to sound funny coming from the trial lawyer, but it really isn't always about the money. In today's environment, dealing with jurors and the way they interpret things, you know, plaintiffs' lawyers are frowned upon very deeply, and so it's very difficult for us to be able to go in and, you know, have this huge target and not have people think that we're out to get millions of dollars. But I'll tell you candidly, a lot of clients want that sense of reckoning. You know, when they feel betrayed, they want to be able to go to an attorney, come to me, come to somebody who does securities litigation and say, this person betrayed me and I want the reckoning. And that's the system of justice that's kind of in play. It may seem a little bit idealistic, but truly, it's not just about the deep pockets, because ultimately the goal is to get the client the compensation that they deserve. Ideally, the agent has their coverage that's going to cover any kind of judgment. And it is about avoiding that appearance that you're just out to get money, because you're not. You're out for the reckoning for the client and representations that were made to them and promises that were not fulfilled.
Well, I was thinking about one of my favorite shows on cable called American Greed, where these scam artists, right? I mean artists that are scamming millions of dollars from older Americans, and then they find out that they're going to get pennies back on the dollar once the scam is unwound and so forth. that there's so much in the heart of the client who's felt betrayed, as you said, even though they're not going to get any money back. They want a reckoning. Actually, they want the most punitive judgment that can be assessed against that person. So I totally get that. But when I'm thinking about it, none of us are attorneys. We have legal language and on the insurance side, policies, and it doesn't matter if it's life insurance, disability, property casualty, errors and omissions, which we all have to carry, which to me sometimes doesn't protect us against what you're talking about. That's a whole other show.
Right.
But it still bothers me that we can't read the policies we sell. We don't even know what they're talking about half the time because the language is so legalese.
Well, and I can't tell you how many times I have deposed in the context of insurance litigation, insurance agents who have sold policies who don't really understand what the coverage is. And let me tell you, as an attorney, it's very, very good evidence for me and for my client when I'm deposing someone who's worked as a captive agent for the same agency for 25, 30 years, and I ask them, does your policy cover loss of consortium claims? I don't know. Does it cover pain and suffering? I don't know. Does it cover medical payments coverages that are excluded under certain terms? I don't know. And when you have long lists of an agent who's made an entire history, an entire life that's built upon selling these policies, and then they can't answer the very basic questions about coverage, that ends up being very, very good for me and bad for them. And I'll tell you honestly, it's been frightening how many times I've taken that deposition, and I have been surprised at the answers that I'm getting from these, inner circle recipients. They're on cruises and they're receiving all kinds of contingent compensation for all these policies that they've sold over the course of their professional lifetime, and they can't answer those questions. That's very tricky when they can't talk about whether or not how MedPay interreacts or interrelates with health insurance and how they explain that to customers. That's frightening to me, that I know more about how certain insurance policies work in an automobile context. That shouldn't be. They've been doing it for 30 or 40 years. I've only been in practice less than 20 years.
Well, I'm bothered that you actually know it so well that you know what to go look for. Listen, for more information on how you can protect your practice, although I'm looking for more information to protect it from, just click on the landing page address in the video description. We'll be right back with more from Ilya Lerma.
This is your website. Few people visit, and if it isn't attracting new visitors, it's not doing its job. Now you can drive more visitors to your website through dynamic content and email marketing with CreativeOne's Social Media Elite. Capture quality leads faster and easier. Engage your visitors with informative articles and videos to boost your online credibility. Plus, stay connected with existing clients and earn more referrals. All content is customized for you. It's time to introduce your website to the world. Call your CreativeOne sales team at 800-992-2642 or visit us online at creativeone.com.
In this segment, we're going to talk about how errors and omission insurance may not be enough to protect your practice and your personal property. All from Ilya's best practices taken from her popular keynote address and seminars. I have to say, honestly, we had Ike Devji on here, okay? And by the time he got done, I thought my errors and omissions was worthless. Then I found out my umbrella policy that I use for my home has nothing to do with protecting my misstatements in business. And it was a revelation. And oh my gosh, the email from that. So let's talk about the first thing, errors and omissions. We buy it every year. And if you're security licensed, you have to have it, right? And we're talking about, some of us have it up to 3 million aggregate, several claims. And I, thank God, in my 31 year, I've never had to fall on my E&O sword, but I pay the bill out dutifully thinking that I have coverage. And then when I talk to people like you, I'm not sure my policy is that great.
Well, and that's true, and I certainly don't want to cover territory that's already been covered by your previous speakers, but it is important to be able to read and understand to some limited extent what it is that your policy covers. And if you're not comfortable doing that, my honest advice is to go to a lawyer. Go to a lawyer who sues agents. Ask them to review your policy. Go over your business practices with them and take a really hard look at, are you doing anything that's outside of the scope? Because the most dangerous thing about insurance is the gaps. And that's true of any lines of insurance. If you're dealing with automobile, disability, there's gaps in there that you're not going to become aware of until there's actually been a loss. And that's the worst time to find out that you're not covered for something.
I've noticed in my career, and this is a complaint, and you're certainly I'm willing to have you address it, but it seems like the contracts, whether it's licensing with any one company, carrier, fund, we're engaged with them to sell their product line, it seems like the contracts are so one-sided. Everything protects them. We are liable for everything on our side of the issue. Have you seen that? I mean, as far as that kind of thinking, or am I just imagining that?
Well, obviously, the contract drafter is always going to have the terms one-sided, and if you're dealing with a large corporate entity on the other side, you don't really have the negotiating power to insert additional terms. If you're more equally yoked and it's a contract that's being gone back and forth between the parties, you want to make sure that you're with somebody, that you're being represented by an attorney who's used to dealing with contract language, contract interpretation, so that yoke gets a little more equal between you and the other party. But as far as dealing with corporate entities, it is true. They have a much bigger bargaining power than you do. And whether or not that's fair to you is going to have to be determined based upon the context of any litigation that might arise. But you're right. The contract drafter is always going to slip in terms that are going to be a lot more favorable to their side than to yours.
Well, one of the things that I found out about a decade ago was one of my friends who had the same Arizona emissions policy I had, went to arbitration. The E&O did not cover it. I was surprised. And I thought, well, it wasn't fraudulent. There wasn't any deliberate harm, but it fell into a gap, as you said. And so they did not pay the claim. So I went back and said, okay, I need to get it. That bothered me. So I said, I need to get something that my standard bearing broker dealer who told me to buy it, I'm not going to buy it if it's not going to cover me, right?
Right.
So we're doing now, we have to do due diligence as agents. We have to do this on our own policy for ourselves. And then finding out, like I told you earlier, that my umbrella policy, which I thought had some kind of protection if they came after me personally, may not cover my practice issues that I do in my business. Now see, Elia, as an attorney, I'm just saying, we don't know what we don't know until we go in front of the attorney or the arbitration or the trial.
Well, that may have been true maybe 15 or 20 years ago. But I think the advent of the internet and having so much information available, it does put the onus on the agent to go out and do some of their own investigation, to be able to look up this information, to be able to do their own investigation. And it is work. I mean, it's nobody likes having to sift through contract language. It's not a lot of fun. But the more you become exposed to it and you know what to look for, you're going to see professional journal articles that warn against certain clauses in E&O coverages or absence of coverages. I mean, you can go on any professional liability policy for lawyers or for physicians and talk about tail coverage, and you're going to find a lot of information so that when you actually go to execute a contract of insurance coverage, you're going to want to know, does this have tail coverage? What's the period? What are the terms? So exposure is really it. Don't just take the contract and bury it. Take some real time. I remember my first week of law school, it was like learning a brand new language. And the learning curve was sharp. But once you become exposed, these are industry terms, not just for lawyers, but they are for financial professionals, CPAs, accountants. We should all be somewhat familiar with what the terms of the contract are, how they operate. And that's what I was saying in the previous segment, how shocking it is when these industry professionals don't really know. You have the tools now. You can't claim ignorance. It's out there for you to be able to go and investigate, what does my policy cover? What are other people saying? There's blogs out there, there's Facebook, there's LinkedIn, there's all these places where people can complain about the coverage or lack of coverage that they had, or give stellar reviews in terms of the company policy that they did obtain. And those are all resources. They're right at your fingertips. And it only takes a few hours. And if you make a practice every year or upon renewal of your insurance contracts, ask your agent, have those ongoing dialogues. Let them know that you're going to be someone who's questioning, what does this actually cover?
Well, I'm thinking when you said language, I'm thinking, well, everything's in Latin. How am I going to get through it? Listen, for more information on protecting your practice and personal property from lawsuits, just click on the landing page address in our video description. And for more information on all our shows, seminars, and workshops, just follow us on social media or visit us out on our website. I'm Steve Savant. We'll see you next time on Thought Leaders. And remember, keep thinking outside the box.